If I can have everyone's attention, please, I'll call the meeting to order. This is the January meeting of the Wilson County Board of Zoning Appeals. Do we have anyone with us this morning that has a case on the agenda that they would like to withdraw or defer to a later meeting? If we don't, our agenda will remain as published. We have a court recorder here with us this morning that's taking a record of our proceedings. The court recorder is supplied at the expense of Wilson County. If you would like a transcript of a particular case, that would be at your expense, and to obtain that transcript, you'll need to see the court recorder at the conclusion of the meeting this morning. Just a reminder to everyone, if you would please silence your cell phone. If you do plan to come forward and make a statement in front of the board this morning, you'll need to be sworn in. So at this time, if you intend to speak, please raise your right hand. Do you solemnly swear or affirm that the testimony that you're about to give in front of this board will be the truth, the whole truth, and nothing but the truth, so help you God?
I do.
Thank you. As we move into the agenda, I will read the case. We'll hear staff comments. Then if you would please come forward if it's your case, and we'll give you an opportunity at the podium to say whatever you'd like to say to the board. After the applicant has had the opportunity to speak, then we'll open up the floor to anyone else who wishes to address the case. The staff has made recommendations to the board in regard to each case, and we will be considering those recommendations as we render our decision. Just as a reminder to everyone, I guess we're on TV this morning, we usually are, so the cameras are normally on. This will be a recorded broadcast. You can watch it later if you so desire. The state mandates that we have a public comment period before each public meeting. This comment period is of a general nature. It does not pertain to any particular case. There'll be another comment period as each particular case is heard. So if you have any comments that you would like to make this morning from a general comment perspective, we'll hear you at this time. Mr. Jenny, is there a time limit on comments, this new law, or no?
You're allowed to place a reasonable time limit on it. I think the county has done 15 minutes with a limit of 3 minutes per person.
How long do we have to remain open if there's no one who wishes to speak?
Nobody moves, you close it.
Okay.
That's what we've been doing in all offices.
Okay. This is a relatively new law we're dealing with, so I just wanted to ask that question. So if there's no one who wishes to address the board on a general nature, then I'll close the general public comment period. To the members of the board, you had an opportunity to review the minutes from our December meeting. Are there any corrections we need to make to the minutes from the month of December? And if there are no corrections, do I hear a motion to approve December's meeting minutes?
So moved.
I have a motion. I'll second. Any comments? If not, all in favor vote aye. Aye. Opposition vote no, and the ayes have it. Okay. Mr. Manning, Miss Robinson is not here, so you'll sit this morning. Yes, sir. All right. Our first case to be heard, case 4141. Gilbert Polindo is requesting a variance of 5 feet from the west side yard setback requirement of 10 feet. The variance will allow the proposed accessory structure to be 5 feet from the west side property line. The property is located at 6523 Greenvale Road, Lot 1, Armstrong property, parcel 4.05 on tax map 165. The property consists of 1.16 acres and is zoned A1 agricultural. We'll get staff recommendations now on 4141.
Mr. Chairman, Mr. Gilbert Polindo is requesting a variance of 5 feet from the west side yard setback requirement of 10 feet. The variance will allow the proposed accessory structure to be 5 feet from the west side yard property line. This is a newer lot of record that was created by plat in October of 21, and there appears to be no geographic or geologic hardship that would justify this variance. Therefore, staff cannot recommend approval. It doesn't really cause an adverse effect to us on site, but practically speaking, but by the letter of the zoning ordinance, we cannot recommend approval.
Okay, who's here to represent 4141?
I am.
Yes, sir. Give us your name and address for the record, please.
Sure.
Have the pictures been passed down?
Yes.
Okay.
First of all, thanks for being open today. I know it's cold, so appreciate you allowing us to come and address you. My name is Gilbert A. Polindo, and my address and the address for this particular case is 6523 Greenvale Road, Watertown, Tennessee. What I'd like to share is that in August of 2023, we moved into this property. We're the first homeowners in this property. Upon moving in, we noticed pretty quickly we were going to have to extend our driveway to allow for our vehicles to park. So we added onto our driveway. We paid attention to being 5 feet from the existing property line on the west side. We were fortunate enough the following month to sell our home in Smithfield, Tennessee. And upon that time, we've got a lot of extra stuff that we couldn't put anywhere. So right now we are renting a storage unit in Lebanon, and it's just been a hassle going to the storage unit. It feels like every other weekend to get stuff. So we considered building a secondary detached garage on top of the extended driveway we built. In doing so, we looked for contractors to do it. We finally found a contractor that was willing to do it. We wanted a contractor that was going to pull a permit to do it by code, and that brings us to where we are today. So we pulled the permit. I think someone on the team noticed that, hey, you're only 5 feet from the property line versus the recommended 10 feet, and that led us to where we are today.
If you,
Sorry.
no, I'm sorry. You go ahead.
Yeah, so we went to our neighbor to talk to him about it as well, just because our neighbor to the west of us, I think he says he has about 80 acres there where this structure is going to be built. I think the picture is on the screen. It's in the bottom right-hand corner of what was on the screen. So there's, right behind there's like a creek.
It's this lot right here. And it's on this side of the lot where my cursor is.
There's a picture on there before. I don't know if you're able to pull that back up. Yeah, so on the
That's the barn that was there prior to the house, but
so there's a little that where you see where our blue line, our property line is highlighted in blue. There's a set of trees that kind of makes a pointed corner on the bottom. So the secondary structure is going to be right around there. So there's really nothing behind it but trees
Right.
and a creek there. So after speaking to our neighbor, he didn't really say he was for it or against it. We just wanted to let him know we were doing that. I'm sure he was informed of this. But that's where we are today. We're just trying to get all of our households into our property and not having to rent a storage unit for properties that don't fit inside our own. So we wanted to construct a metal barn on the existing extended driveway that's there in order to support those requirements.
and briefly, there's no there's as long as the driveway is on the property beyond the front property corner, they can go right up, as long as they're not encroaching on an easement or something, they can go right up to the property line, but not cross it with a driveway. Where the problem comes in is if they plan to cover it with a structure within 10 feet. It does appear they did pour, if you'll look at the pictures that were passed down to you, there's one with a Jeep in it. That appeared to be a new pour that was kind of a turnaround extension off of the driveway. And that appears to be where they are proposing to cover with the metal barn. Is that correct, Mr. Polindo?
Yes, sir. Yes, sir.
Tom, is this in the rear yard or side yard, or does it matter?
It's kind of in the side. It doesn't matter.
It doesn't matter. The setback would be the same whether we're in the rear yard or side
accessory.
yard.
Yes.
Okay, does the board have any questions for the applicant?
I got one.
Go right ahead.
You do have a picture in your packet that I prepared in case the PowerPoint didn't work. That shows the area pretty closely.
Go ahead, Howard.
Yeah, this permit that was pulled, it says it's supposed to be a business.
Yes, sir.
So are you running business out of this residence?
No, sir. There's a company that we hired to hopefully build this metal garage.
Okay, so the applicant is the piece of people you hired to build.
Yes, sir.
Okay.
They said they would pull the permit on our behalf, and as I understood, that's what they had been doing in the county.
Okay, well, Three Boys Consulting is the place.
Yes, sir.
Oh, yeah, it's not the people that's gonna be on the property.
No, sir.
Okay.
They just pulled the permit for us, and they told us that was their normal practice in Wilson County, is to pull the permit themselves through the county before commencing work.
Okay.
Other questions from the board for the applicant?
Yeah, what would be an issue with you moving it towards the house 5 feet, other than it looks like you already have your pad poured?
I think just the length of a couple of our vehicles. I think if I moved it forward the way that the driveway was built, there wouldn't be a way to fit the vehicles in there if I moved it 5 feet in, sir.
Other questions for the applicant? If not, then is anyone else here wishes to speak to 4141?
Mr. Crockett, if you look at the second page back, you kind of you get a good idea of what kind of distance is between the house and the kind of the cutout pour. It's the pour is behind the last vehicle where they're wanting to build this shed or garage.
Which,
Kinda gives you an
which
idea of
packet are you referring to, Tom?
I'm sorry, this one. Second page back.
And this picture's taken from the road?
Yes.
I'm assuming the poor's right behind this building here.
It shows good on here.
There you go. This is a picture we don't have but one set of.
Yeah.
See that? Okay. Okay. Does anyone else here wish to address case 4141? Okay. If not, then we'll close the public hearing period on this case. Thank you, sir.
Yes, sir.
Turning to the board now for discussion and or a motion.
In the past, have we passed these where it's 5 feet where you're, I mean, that's 50% of the variance. I don't know, have we gone that?
I mean, it has been granted before, if that's
Okay.
your question.
Okay.
Well, every case is different.
Right.
Down in places like Pebble Point, where we have a lot of older lots and whatnot, then, we've issued some pretty significant variances down there, but they go back to lots created in the 50s.
Exactly.
This is, the evidence in this case is quite a bit different. Case 4141, do I hear a motion?
Mr. Chairman, I will move that we deny this case based on staff recommendations.
Have a motion to deny 4141 based on staff recommendations. Do I hear a second?
I'll second.
Have a motion and a second. Any discussion? If not, all in favor of the motion vote aye. Aye. Opposition vote no. And the ayes have it. Thank you for coming, sir. Okay. Our next case will be case 4142. Joyce Brody is requesting a variance of 9 feet from the rear yard setback requirement of 40 feet and a variance of 7 feet from the side yard setback requirement of 15 feet. The variance will allow the proposed sunroom to be 31 feet from the rear property line and 8 feet from the south side property line. The property is located at 682 Corinth Road, Lot 13, Boyd Acres, Group B, Parcel 12.01 on Wilson County Tax Map 118K. The property consists of .69 acres and is on R1 residential. Get staff recommendations now on 4142.
Mr. Chairman, briefly, I'll circle, I believe where this project is proposed. I believe it's back in this area, behind the house. Joyce Brody is requesting a variance of 9 feet from the rear yard setback requirement of 40 feet, leaving 31 feet to the rear, and is requesting a variance of 7 feet from the south side yard setback requirement of 15 feet, leaving 8 feet. The variance will allow the proposed sunroom to be 31 feet from the rear property line and 8 feet from the south property line. This is an older lot of record that was created in 1963. The side yard setback request is for the existing structure, in addition, which has been in place for some time. Staff sees no adverse effect in granting this variance request, as the sunroom appears to enclose an existing porch area predominantly, and staff can recommend approval. And again, this is due to the era of the lot and the home,
Would you say it was-
predating our zoning ordinance in 1974.
You said this lot was created in 63?
That's my research indicates that.
Okay. All right. Who's here to represent 4142 Brody? Okay.
I'm the contractor. My name is Jay Maltsby, with Prestige Remodeling.
Address, please. Your address.
682 Corinth Road, Mount Juliet.
Okay, and you're representing Miss Brody? Are
Joyce
you Miss
Brody.
Brody? Okay. Go right ahead, sir.
There's an existing structure there. The structure has been there for some time. Prior to her even purchasing the home or buying the home, we're wanting to build an enclosed sunroom so that they can enjoy the outdoor space. The current home sits right on the side setback and rear setback, so there's really no room to build this structure anywhere other than, off the front of the house, which would be kind of awkward. So we were hoping that we could get granted a variance to essentially remove the current structure and build an enclosed sunroom structure.
Okay. Does the board have any questions for the applicant?
I have one for the applicant, Mr. Chair.
Go
Mr.
ahead.
Mosby, you stated your address was 682 Corinth. That is the address of the location. Are you living
That
there?
is-
That's her
that is
address.
Joyce.
I think he was asking for your address.
Oh, my address, it's 6653 North Lamar Road, Mount Juliet.
Does the board have any questions for the applicant? Okay. Does anyone else here wish to address 4142 Brody? If not, thank you. We'll close the public comment period. And turning to the board for a motion in regard to 4142. I'll move to approve the request of 4142 based on staff recommendations that this is a older lot of record. Do I have a second?
Second.
Have a motion and a second. Discussion by the board. If there is no discussion, all in favor of the motion vote aye. Aye. Opposition vote no. The ayes have it. Thank y'all for coming. Our next case is case 4143. Garner Construction, on behalf of Brandon Richardson, is requesting a variance of 4 feet from the setback requirement of 8 feet between structures. The variance will allow the detached garage to be 4 feet from the existing house. The property is located at 2130 Barnes Drive, Philip Craighead property, parcel 113.01 on Wilkes County Tax Map 57. The property consists of 5.53 acres and is zoned R1 residential. We get staff recommendations now on 4143.
Mr. Chairman, I will again point out, the entrance to this is predominantly in the city of Lebanon off of Barnes Drive. If you look at the cursor, this is Barnes Drive, and it goes down a large driveway flag lot that serves a couple of lots that fall just outside city limits of Lebanon. This is back in the back of South Fork subdivision, more or less, just so you're aware of where it's at. And
Tom, would you take your pointer? Tell me, where's the street frontage on this?
street frontage is down here.
Okay, on
Barnes
South Fork
Drive.
Drive.
It's Barnes Drive, south,
Okay.
parentheses Southport Drive, but I believe it's Barnes Drive, and then it's got a long driveway. Yeah, and then it has a long driveway, gravel driveway, and then I've got a blow up of the buildable portion of the lot, which is down at the end of the flag stem. And the house, if I'm correct, the house is generally in this vicinity, and the accessory structure is right in here. And, oops, back up, sorry. So anyways, Garner Construction, on behalf of Brandon Richardson, is requesting a variance of 4 feet from the setback requirement of 8 feet between structures. This is a newer lot of record created in 2020. While the variance request would appear to cause little adverse effect, staff cannot recommend approval given the language in the zoning ordinance. Additionally, and you'll see this in the pictures that are being passed down, as well as in your packet that I pointed out a minute ago, a few pages back under case 4143. The steps from the rear porch of the house appear to be within approximately 2 feet of the post on the covered back porch of this accessory structure. Actually, in the packet in front of you, I don't know, about 7 or 8 pages back, you start to see the front 4 foot setback variance they're asking for, and then on the back there's a picture of the steps, and then I've got a piece of paper in there just more or less for scale on the ground between the steps and the post.
Okay. That's all you have?
Yes.
Okay. Who's here to represent 4143 Garner Construction? Yes, sir. Name and address, please.
Just to clarify, you want my personal address is 6950 Southeast
Yes,
Taylor
the-
Peeler Road.
The address we're asking for is your personal, where you live address, so we keep it on the record.
Yes. My name is Adam Garner, representing the Richardsons. The pad that we're building on is an existing pad. So there was a structure on that at some point in time. And so what I'm
When
requesting.
you say pad, you mean the concrete pad or the
Concrete
dirt pad?
Correct. We did add an additional portion to that pad, and that's where he's referring to with where those steps are. So what I'm requesting is the variance due to the pad, pre-existing pad being there.
Wouldn't that mean the house then was in violation?
When we started this project, the pad was there. There's a pre-existing that had a structure on it at some point in time. So I'm requesting this be granted with the pre-existing pad already in place.
The house appears to be fairly new construction.
You
As
said the lot was new, right?
it was recorded in 2020.
Okay, go ahead.
The house appears to be fairly new construction. The accessory appears to be fairly new construction. I am not sure which one was chicken or egg, which one came first. I don't know if Karen has any insight on that or not, but at any rate, the separation they're asking for, we typically require 8 foot wall to wall between, or wall to post between structures. They've asked for a 4 foot variance, I think predominantly associated with the primary accessory structure and primary home. Back here at the porch and the steps, you're within 2 feet, so they may need an additional 2 foot of variance, maybe a 6 foot variance instead of a 4 foot variance, to allow that 2 foot separation. The other alternative would be that they provide some sort of minimal connection, maybe 5 foot wide, between the house and the accessory structure by roof line.
Just to clarify, there is a fireplace at the house, and that's where the 4 foot is coming in at. So it's actually 6 foot from wall to wall. But what we're looking, that measurement is between the fireplace.
Yeah, and what I was referring to is back here at the
Understand.
steps
I
and the
just wanted
post.
to give more clarification.
Okay.
Well, let's back up a minute here. The lot was platted in 2020. We understand that, right? So was the house there prior to the platting, or is this a replat, or is this a new house?
I'm not aware of the home's construction. There is a separate contractor working on a remodel in the home, but I am not a part of that portion.
And you say that you're building on an existing slab, but
That's
you don't know
correct.
what was there before?
I do not, no.
Okay,
But it was an existing slab.
gotcha.
Now, just to clarify, we did add a portion of that slab in the back. What you're,
Back where the covered porch is,
yes.
of the accessory structure.
Could the existing slab just been a concrete parking?
I don't believe so, because there was J-bolts inside that slab, so that leads me to believe that there was some type of structure on that pad. Garage. I'm assuming it was a garage, but I don't know for sure.
Board have other questions for the applicant? No? Okay. Thank you, sir. And does anyone else here wish to speak to 4143 Garner on behalf of Richardson? Good. If not, I'll close the public comment period on this case. And now turning to the board for any discussion and a motion.
I got a quick question for staff. If this were in the city limits, I know it's not, but if it were, would it change anything? I'm just
Well,
thinking
it would
this-
follow city regulations, and I don't know
You don't know what they're
right off the top of my head what they are.
And that may not have any bearing here. I just thought it could have, somebody could have made a mistake and went by the city when they were doing this instead of the county. But, you know.
Mr. Thompson?
Yes.
I got some information in regards to the house, when the
Okay.
house was built, since y'all were asking.
Mm-hmm.
What it shows on tax assessment data is the house was built in 1989.
Okay, so this plat must have been a replat. It's still a new
Right.
lot, but it's a
Yeah.
replat of some kind.
It's a boundary survey. It's large enough. It's not a subdivision plat.
Does it show on the tax assessor any accessory structure?
It states that there's a pole barn and a wood deck.
Okay.
And that's all I see.
All right.
It's a five acre tract, so I wonder if it was cut off after the house was built sometime or another, but
So difficult to go from that type of information. It's handy in a way, but
I know.
hard to depend on.
I understand.
All right. Again, to the board, case 4143. Do I hear a motion?
I'll make a motion to deny the request based on staff recommendation.
I have a motion to deny case 4143 based on staff recommendations. Do I have a second?
I'll second.
I have a motion and a second. Now, discussion by the board. Any discussion on the motion to deny? If there is no discussion, all in favor of the motion vote aye. Aye. Opposed, vote no. And the ayes have it. Thank you for coming.
Mr. Chairman?
Yes,
just, in this particular instance, since both constructions appear to be near completion, the house and the accessory structure, I think the easiest thing might be to provide some sort of roof line connection between the two, and your setback issue would not be an issue at that point between the structures. Just for what it's worth.
Is there any requirements on the
No, I mean, just basically by roof line, about 5 foot
If
wide or
y'all
so.
don't mind, you can have those discussions any other time.
All right,
But
no worries.
not now. Okay. Case 4144. Ken Beeler is requesting a variance of 35 feet from the rear yard setback requirement of 40 feet. The variance will allow the proposed deck to be built over the existing patio and be 7 feet from the rear property line. Property is located at 5473 Vanderbilt Road, Lot 19. Nobblehurst is Group B, Parcel 8 on Wilson County Tax Map 50A. The property consists of .296 acres and is zoned R1 residential. We get staff recommendations now on 4144.
Mr. Chairman, Ken Beeler is requesting a variance of 33 feet from the rear yard setback requirement of 40 feet. The variance will allow the proposed deck to be built over an existing patio and be 7 feet from the rear property line. This variance request is to cover an existing patio with a deck. This lot is an older lot of record, being created in 1952. The rear yard setback, leaving only 7 feet to the property line, is adjacent to the Corps of Engineers and Old Hickory Lake. Staff sees little adverse effect if the variance is granted, and staff can recommend approval. And briefly, if you look at the cursor on the map, it's back in this general vicinity. It's where the
Gotcha.
patio is.
Okay. Who's here to represent 4144? Beeler.
Yeah, I'm Ken Beeler, property owner. My address is 5473 Vanderbilt Road. The existing property has a 30 to 12 foot concrete patio off the back of the house that is covered, has a roof over the top of it. We sustained, if you look at the pictures, we had a lot of trees. July of last year, we lost all of our trees in a straight line windstorm. So we had damage to the property and to the house and to the roof. So the roof of our patio was damaged at that point where tree limbs punctured it. So we thought it was a good time, instead of just repairing the roof that existed, is let's just build a deck over the top of the roof so we could access it from our second story. And then we did the property line survey. If you look at the property line, it appears that our house is actually built on the core property, so we provided a survey. Then we have our existing house at the closest point is like 7.5 feet off the Corps Engineer property. And we just want to build over that same structure.
Effectively, it's building over the top of where would have been an existing ground floor porch area. It may be minimally larger just from the standpoint that they wanted to pour new footings and post outside of the existing concrete so as not to damage the existing concrete slab. Is that correct, sir?
It would be, so we didn't have to cut out the corner of the slab, minimize damage to the slab. We was just going to set the post on the outside and each side, so that would make the deck a foot wider on both ends. Same width, same distance off the house, just wider, which would match the actual outline of the house.
Does the board have any questions for the applicant?
So basically, you're just rebuilding what was up there and adding walls.
I'm,
Gonna enclose
it's a
it.
roof now, and I'm
Right.
just putting a deck
Okay.
over it.
Thank you.
Any other questions? Okay. If not, does anyone else here wish to address 4144 Beeler? Is it Beeler or Beller?
Beeler.
Okay, I'll get it right.
That's okay.
Anyone else? Okay. If not, then I'll close the public comment period and turning to the board on case 4144. Do I hear a motion? Any questions for the staff?
A motion to approve based on staff recommendations.
I have a motion to approve case 4144 based on staff recommendations. Do I have a second?
Second.
I have a motion and a second. Any discussion on the motion? If not, all in favor vote aye. Aye. Opposition vote no. The ayes have it. Thank you, sir.
Who was the second?
Mr. Neal.
Can I have one question? So the next process is to go through the permitting process?
I don't know where you are in the process, but that's,
I hadn't started.
oh, you got through this one.
Thank you.
All right. Our next case is 4145. Nettie Freed, on behalf of Spellbound Records, is requesting to renew approval for a short-term rental in conjunction with a recording studio. The board approved the request on November 17th, 2022 for 1 year. The property is located at 1067 Jennings Pond Road, Lot 14, A.E. Hooper property, parcel 17.15 on Wilson County Tax Map 142. The property consists of 5 acres and is on A1 agricultural. We'll get staff recommendations now on 4145.
Mr. Chairman, the board approved this request once before on November 17th, 2022, for a period of 1 year as the bed and breakfast provisions are basically effectively all short-term rentals as defined under our bed and breakfast definition are required to be approved for a finite period of time. And that's what you did in November of 2022. The applicants are back before you for a renewal on this property. Staff have had no complaints about the property from the original board approval or from the time of the original board approval. Staff sees no adverse effect in continuing this use approval for an additional period.
Okay, who's here to represent 4145? Spellbound Records. Yes, sir.
Yes, sir. My name is Darrell Hill, and I live at 610 Durham Hollow Lane in Dixon Springs, Tennessee.
And you're here to represent this case?
Yes, sir.
Okay.
I'm
And
the
anything
chief
you'd like to
of
tell the board?
operations.
Beg pardon?
I'm the chief of operations
Okay.
for the recording studio.
Okay. Anything you'd like to tell the board?
No, I'm just wanting to try to get it approved again for another year or whatever the process.
Tom, we normally do,
Or is it-
what, 135, something like that?
Okay, whatever it
I mean,
is.
that's your precedent, yes.
Okay. All right. Does the board have any questions for the applicant?
I got one.
Yes, sir. Go ahead.
Do you live on the property? No, sir.
Are you within 10 miles?
My son is.
So he would be
He's
the
the
go-to
caretaker.
caretaker.
Yes, sir. He goes
Okay.
to Karen Lake.
All right.
Any other questions for the applicant? Okay. If not, does anyone else here wish to address 4145 Spellbound Records? If not, then we'll close the public comment period. And then turning to the board for a motion on 4145. I'll move that we approve the request this time for 3 years with the stipulation that all of the original stipulations and criteria that governed your approval are attached to this 3-year approval. Okay. That's my motion. Do I have a second?
Second.
Have a motion and second. Discussion by the board.
Who seconded
Mr. Blades.
that? Thank you.
If there's no discussion, all in favor of the motion, vote aye.
Aye.
Opposition, vote no. The ayes have it. Thank y'all very much.
Thank you very much.
Who seconded?
Mr. Howard Blades.
Okay.
All right, our next case is case 4146. Landmark Homes of Tennessee is requesting an extension on a building permit that will be expiring on February the 28th, 2024. Construction has not begun, and the building permit hasn't been issued. The property is located at 830 Molly Lane, Lot 33. The Oaks is Group A, Parcel 34 on Wilson County Tax Map 122H. The property consists of .25 acres and is zoned R1 residential. We get staff comments now and recommendations on 4146.
Okay. So Landmark Homes, that for the first one, they're right next door to each other. I don't know if you can even see it on here. It's right in here. And then go to the next slide. Well, I'll do it. Yeah, that's it right there. And effectively what you see is what's out there, except it's a paved dry road in front of it at this point, I believe. So Landmark Homes of Tennessee is requesting an extension on a building permit that will be expiring on February 28, 2024. Construction has not begun and the building permit has not been issued. There's no language in the zoning ordinance that would permit staff to make such an extension upon request. We therefore cannot recommend approval. So if I understand correctly, they applied in February of 2021 or 2. In 2022, February of 2022.
2023.
2023, I apologize. So they applied in February of 2023 and they have not made any progress. and they're asking for an extension rather than having to pay again.
Well, just let me make sure I understand what the ordinance says. If they were to begin before the date that the permit expired, then they wouldn't need an extension.
Correct.
But
And
if they don't, they
the
would.
applicant knew that because I told her that, you know, it was good until February. But from what, and I don't.
We'll
think
hear from him in a minute. I just started
I
getting,
don't think she's here. I don't.
we'll,
She is? Oh, okay, I'm sorry. Could not see you.
everybody's bundled up so much we can't.
Yeah, I'll let her speak.
Okay, that's fine. So, Tom, this is not contrary to the ordinance, there's just no guiding language in the ordinance.
No, and I mean, effectively, it may have more impact on the adequate facilities aspects, because if you look at the language itself, it says a building permit shall become void 12 months from the date of issuance by the building inspector or the date an appeal is granted by the Board of Zoning Appeals unless substantial progress has been made within those 12 months on the project described therein. So if it's not been issued, they've applied and they've
And
paid
but-
their AFT.
But the ordinance says issued.
Right.
Better hold up right there.
It says date of issuance by the building inspector.
So they applied for the permit hasn't been issued, they haven't started, the permit hasn't been issued.
It's gonna be hard to extend a building permit that's not been issued, isn't it?
It's gonna be hard to set the time limit ticking a year ago if it hadn't been issued also, so in my mind, no harm, no foul.
We need no harm with that.
Well, I mean, if they haven't started, it hasn't been issued, the time doesn't start until the permit is issued.
But they paid for
They
it.
paid for it. Normally, they would pay for it, they would go out, they would stake the lot, they would do what they're supposed to. The permitting person would go out and look at it and issue a permit based on all the above requirements being met. They haven't done anything. So the permit has not been formally issued. It's still in limbo over and on.
So what do you say?
So I'm saying nothing has happened.
Right, I understand
The
that.
time frame has not started ticking because we say it's 1 year after it's issued. But if you say it's after it's issued, it needs to be after it's issued, not when it's applied for.
I guess I'm thinking about the precedent on this. Rusty. Let's say, and there's nothing in the works that I'm aware of, so nobody get excited, that the county votes to increase the adequate facilities tax, and people come in here and make all kind of applications, but don't act on them to beat the increase in that adequate facilities tax. I don't know if that's good practice for the county.
I don't know that either. That's why I turned around.
In the paragraph preceding what I read to you, it does also say, the building inspector shall within 3 days issue a building permit for such excavation and construction. And that's not been done either because it's not been requested.
So they could still get their building permit between now and February 28th. If not, they've lost the right to do it.
Yeah.
I assume you and I are saying the same thing.
Well, in essence, we are. They have, roughly a month
They do.
to ask for the permit to be issued, and then they go right on.
Does that give them a year from that month, or do they have to have substantial progress within?
It gives them actually more than a year if they maintain substantial
Right,
progress.
right.
Well, the window for substantial progress would be a lot less because there's only so much you can do for 5 weeks.
Well, I think
So if they broke ground and started pouring concrete,
I think the permit is a year or as long as substantial progress is made in it, Karen. I mean, is it
I believe, is 24 months.
24 months?
Yeah.
The maximum, it's supposed to be finished within 24 months.
Okay.
I think the request may be a little premature. It's going to be hard in my mind, and I'm just speaking for myself, I don't have a vote, but it's hard to vote to extend something that hasn't been issued.
That's a good point. Good point. I think we should hear the rest of the testimony.
Yep.
Okay. Who's here to represent 4146? Were you through, Tom?
I'm sorry?
Were you through?
I was.
Okay. Go ahead, sir. Name and address,
Good
please.
morning. Richard Stever, 4957 Smiley Road in Chapel Hill.
And you are Landmark?
Yes, sir.
Okay, go ahead.
So we turned in the permits along with 4 other spec homes back in February. We still have the other 4 that haven't sold yet. Our plan was to start the other 2 as soon as we sold one, so that's why they haven't started yet. But from what I'm hearing you guys discussing this morning, I don't think we really have an issue. We must have misunderstood that we had to pour footers before February this year, which is why we were requesting the extension.
I don't think that's the case, is it?
Do you, I've got a copy of your permit, but I don't have the whole file.
Okay.
Did you submit a survey or a stamped plot plan? Do you remember whether
I don't remember. That would have been another person in our company that's not here, not with us any longer.
Okay. When they submit a stamped plot plan, then they can start digging the footers, and the permit is issued at the same time as the footing inspection. I just made a copy of the permit. I didn't make the whole copy of the whole file, so it depends on whether that may make a difference.
But
or not.
is that something that has to be done that way, or is that just policy since it's handy for them to do it while they're out there?
It's policy. If they do a stamped plot plan, then the permit.
But if he handed you a stamped plot plan and said, I want the permit issued,
If he wanted the permit issued, then if that's what he requested.
I mean, you don't
that's what-
require him to have footings in the ground to issue a permit. So if he were to say, here's whatever you're lacking, we want the permit issued, then the process could move forward at that point. He'd have his 24 months.
And just for what it's worth, Stormwater is also on a time clock with their stormwater permit that was issued in February of 2023 as well. So
So was it issued or requested?
it was actually issued. Yeah.
Okay.
I want to ask a question here. So I could not have all my ducks in a row, so to speak, but I could go and apply for an application for a building permit, and I would receive that. Then I could go along and get my ducks in a row and come back and get it issued. Is that correct? So they don't really go hand in hand. I can do this and
I'm
not
not
be
hearing
ready.
that here.
Do what?
I don't know that I'm hearing that here.
I'm asking as a question. What I'm saying is, you came up and didn't have everything, your plat stamped or anything like that, but still got a permit.
He applied.
He applied.
Okay.
He does not have, he's got an application where he applied for a permit. He does not have an active.
Or his
building
company
permit.
applied. I don't know that you did it.
He doesn't have an active building permit because it hasn't been issued yet.
I guess my point,
It's still in.
a long way around, it ought to go hand in hand. You should have a certain, pretty quick time to apply for this and have all your things in order, then issue a building permit. So you have a year to get your.
I don't
building
know that
permit.
there's any time frame that limits the amount of time it takes you to go through the process. You know, if you were to submit some of your information one day and some 6 months from now and so on and so forth, and maybe we'll have a comment on it and it goes by. I don't know that there's any, matter of fact, I'm pretty sure there's not a time frame.
That's just where I
What,
kind of see an issue. There ought to be some time
Well,
period to have
Kind
it
of
together.
getting to what I think Mike was saying, we don't need an issue where some builder comes in here and applies for 20
permits
building permits and just sits on them for
and
5
says, I'll
years.
get to it when I get to it.
Yeah, exactly. Well, I just want to, you know, they haven't been issued, so therefore they just sit around for years and years and years.
That's my point.
Yeah.
One element of this is this gentleman is paid. You know, he's paid for his permit and his added facilities tax, which is a little bit different than the way things happen sometimes when people are just submitting a preliminary plat or something of that nature. The fees are much less. Okay. All right. Does the board have any other questions for the applicant?
Mr. Chairman,
Yes.
I don't know if this will muddy the water or not. Not intended to, but is the application even complete? If they haven't filed a plot plan to show what they're going to build, is the application?
No, we have to have a plot plan. Everything, she can't apply for, anybody that comes in can't apply for a building permit if they don't have everything that we need in regards to applying. So she wouldn't have the application process finished if she didn't have everything we needed.
So you're thinking there is all this.
I'm not sure whether there is a stamped plot plan on there. Some people do a stamped plot plan by a surveyor. Some people draw out a plot plan themselves. If it's less than 5 acres and they draw a plot plan themselves, then the permit, the setbacks have to be checked and the permit has to be issued first before they can start any construction. But if they have a stamped plot plan and it's less than 5 acres, then they can proceed with their footings and the permit's issued.
And setbacks and footings are inspected simultaneously.
And back to this, the way I think I'm hearing things is that I can come in and pay you an application fee and file my application. Second part is getting a building permit and I have to pay for it at that time.
No, they pay
No,
when
they
they
pay.
pay. You have to pay when you file the application.
But I thought our building permits were based on square footage.
It is, and she's paid the fee.
They won't let you make application unless you have a certain bank of information with you.
Yes, and you have to pay the fees. You have to pay the adequate facilities tax and the building permit fee.
Based on square footage.
But I thought you said there was nothing on there.
No,
I may have
she's
misunderstood.
She's
Okay.
paid for,
Never
she's
mind.
paid both fees.
She's paid for a house plan on
Yes.
the property.
And we have all the information that's required for her to apply for the
I
permit.
think the application for a variance is premature.
But it could. I think I know what I do. But I don't advise it. But you and I think the same.
What if they don't do anything and February comes and goes?
Well,
Permit hasn't been issued, so
that's another discussion about the adequate facilities tax too. That becomes a question of whether or not their payment would have to be repaid if they wait that long. But that's, I don't have the AFT information in front of me. My opinion, they ought to do something between now and February 28th and forego this.
Mr. Chairman, my thinking is that the applicant may want to consider deferring.
Deferral or withdrawal? Deferral or withdrawal?
Either one, and make a new application. That they could request a deferral if they thought they would need time. Insurance.
Okay. I think I got it. Okay. Does anyone else here wish to address 4146?
I've got a quick
Landmark.
question, if you don't mind.
Go ahead.
So if we pick up the permit before February, we have 24 months to finish the house. I don't think it'll take that long.
As long as you're
but-
making substantial progress.
Right.
And at least initially, you could make substantial progress by requesting a footing
No,
inspection.
this will go away.
if
Now-
the house is staked off,
Mhm.
and we went out there, but I can't remember whether it was staked off or not.
I don't
But if
believe it
you-
is.
I don't think it was.
If you get the house staked off, then you can call in and tell us the house is staked off and we'll come out and issue your permit.
Okay.
Now, you have three options as we see.
I just want to make sure that, you know, if we don't have to pour footers by February 28th, with the cold weather, it may be tough, but we do plan on finishing this house, both of these houses this year, so I have no problem going and getting
So
the
you have
permit
three
issued.
options. You can either A, ask us to act on the request as it's stated.
Mhm.
B, ask for a deferral, or 3, you have the absolute right to withdraw.
Mhm.
So it's up to you.
I think we'll just withdraw. If my statement's correct, if I can just go pick up the permit before February 28th. then-
Okay, in regard to case 4146, as a representative of Landmark Homes of Tennessee, you wish to withdraw.
Yes, sir.
Okay.
Now, to be clear, that means you're going to request your first inspection, whatever that may be.
Correct.
Whether it's a
We'll
zoning
get it
setback
staked out
inspection or
and-
footing.
Yes, yes,
All
sir.
right.
All right, the applicant has requested withdrawal. If there's no one else here who wishes to speak in this case, I'll close the public comment period. Thank you, sir.
Thank you.
And in regard to case 4146, based on the applicant's request, I move that we allow him to withdraw. Do I have a second?
Do we have to vote on withdrawal?
Yes,
Okay.
I think so.
How about
Do I have a second?
second?
I have a motion and a second. Any discussion? If not, all in favor vote aye. Aye. Opposition vote no. The ayes have it. Okay. Are you gonna do the same thing this next, well, it'll go a little quicker if I know what's gonna happen, okay?
The next item is case 4147, 828 Molly Lane, and it's right next door to the other one.
Okay, case 4147, Landmark Homes of Tennessee is requesting an extension on the building permit that will be expiring February 28, 2024. Construction has not begun and the building permit has not been issued. The property is located at 828 Molly Lane, Lot 34, The Oaks, Group A, Parcel 33 on Wilson County Tax Map 122H. The property consists of .25 acres and is zoned R1 residential. And I'm going to forego staff recommendations. If you would come forward again, please, sir. State your name and address for the record.
Richard Stever, 4957 Smiley Road, Chapel Hill.
It is at your request to withdraw this case.
Yes, sir.
Thank you.
Thank you.
Does anyone else here wish to comment? I don't think that's appropriate, but we'll ask anyway. No one, thank you. Public comment period is over. In regard to case 4147, based on the applicant's request, I move that he be able to withdraw this case. Do I have a second?
Second.
I have a motion and a second. Any discussion by the board? If not, all in favor vote aye. Aye. Opposition vote no. Thank you, sir. Okay. Yes, sir. Well, you better ask it out loud while we're in session. Okay, move on just a little bit here. Okay. Our next case is case 4148. Teresa Bentley is requesting a variance of 2 feet from the height requirement of 8 feet for a fence. The fence is 10 feet in height. The property is located at 1210 Janie Sue Court, Lot 122, Heritage Highlands, Group B, Parcel 24 on Wilson County Tax Map 27E. The property consists of .67 acres and is zoned R1 residential. We'll get staff recommendations now on 4148.
Okay. I'm going to show you a couple things on the screen. That this is the county parcel map prior to the houses in this cul-de-sac being built. One thing to note here, I did post the 5-foot topography that the county has on their online website. This is the lot here, and you can see there's approximately 5 to 7.5 foot drop from this area on this lot down into where general vicinity of where the house is. And then I'm going to click. This is actually the house. This is on Google Maps. This is the neighbor's house. This is this house. The fence is along the common property line between the two in this general vicinity. And you should be getting passed down some pictures from our site review. With that, I'll proceed. Teresa Bentley is requesting a variance of 2 feet from the height requirement of 8 feet for a fence. The fence is 10 feet in height according to the application. On property, the fence appeared to be more accurately around 12 feet in height. The fence was installed due to a privacy and nuisance concern per reports of the property owner here, the Bentleys, associated with the neighbor's second-story eave floodlight, which is also reportedly a ring-style security camera. There's no language in the zoning ordinance regulations that would permit such variance. The specifics is if you have a fence larger than 8 foot in height, it's got to be, I think, 10 foot setback off the property line. This is along the property line. However, this fence was erected presumably, or per reports, from the applicant in response to a property owner dispute, and staff feels there may be consideration given for permitting such a variance under hardship language due to a non-self-imposed hardship associated with the terrain of the property. The entrance to the home on this property is situated downhill from the neighboring two-story structure, and the neighbor reportedly has the floodlight/security camera set in such a way that it turns on every time the residents leave their front door and enter their front yard if the fence is not in place, thus partially blocking the range of the neighbor's security camera for motion detection and light. So if I understand correctly, you have somewhat a disagreement between property owners about a security camera that they feel is an invasion of their privacy, as well as light. And they are down.
Let's just be very clear here. We're not here for any civil issues. Have nothing to do with any lights or cameras or anything of that nature.
Right.
We're here to look about the zoning ordinance.
Understood.
So, were you at the end of your comments, Tom?
I was just telling you that I gave you the topography if you need to look at it.
Okay. All right. Who's here to represent 4148 Bentley? Yes, sir.
My name is Drew Bentley. This is my wife, Teresa Bentley. We are the homeowners at 1210 Janie C. Court, Lebanon, Tennessee, 370787. So this all started October 30th, 2022. I noticed that my neighbor had installed these ring floodlight motion lights. In December, I brought it to their attention just to say, hey, you know, the angle of the light, I mean, you know, it's to the point to where it shines directly through our living room window, where I can make shadow puppets. I mean, I'm not trying to be funny, but shadow puppets on the wall. I brought it to their attention, and I even asked and said, hey, I'll even offer my 28 or 24 foot ladder if you can just kind of position it a different way. They told me they would get back with me. They got back with me and said that per their counsel that they were well within our rights to have the light position where it was at. And, you know, I kind of even talked to them again, was like, you know, even if you were my own worst enemy and I knew this was a problem and it was coming into my living room window, you know, I would move it. So for 3 months, we had to get legal counsel to try to resolve this issue. I mean, it's just basically just as easy as moving a floodlight. 3 months went by, would not do it. So months kept going by, it kept getting worse to the point to where I could step 10 feet, I mean, not 10 feet, but 10, 12, you know, steps off of my front porch, and that motion light would trigger in my driveway. So it never got better, nothing ever got resolved. So then I took it upon myself to say, you know, I'm gonna, even the attorney that we had got representing us the first time said, you know, I'd mentioned about doing some landscaping, some trees, whatever. He thought that was a good idea. So I started to do that. The weekend that I started to erect this, 2 individuals from the neighborhood that now are on the HOA board had a pool party with them next door. A week after that, I got a letter from the HOA saying it had to be taken down. Well,
You're talking about the fence?
yes, the partition fence. So once again, I got another attorney involved, an HOA attorney, because there were discrepancies with the way that the HOA had been handling other properties. Basically told them this is the reason why the Bentleys are doing it. Please advise that if you can continue to come after them, that we'll have to, you know, figure out what else is going on in the neighborhood. I erected it. Everything was great. I even went to the attorney. The attorney, she read the HOA covenant and restrictions, said that it didn't matter. I know that doesn't matter for the zoning because it's different parties, but she said there wasn't an issue. She replied back to them saying that, you know, leave us alone. Continues to get worse. It's better now because I don't walk out of my front doorstep and have that motion light trigger and come on. It got to the point where I was trying to back in my driveway and it would always have this light sitting right here. Can I show you these, or would you guys be willing to take a look at these?
Sure. But I'll remind you again, we're here to hear
no,
a
no,
zoning
I'm just-
variance,
no.
not to hear a discussion about the neighbors and what the HOA
understand
did.
that. I
None of that's
understand.
relevant to what we can consider.
I understand, but like Mr. Brasher said, I went out there, it's the angle of the light. There's a 44-inch difference in the elevation of where their driveway is and where our driveway is. So there's almost a 4-foot difference from where the position and the heights of the house are. So the 2 foot extra does help.
I understand, but you're showing us pictures of the light, and we don't have anything to do with the light.
I know that, but what I'm saying is the extra 2 feet of the fence, sir, is helping me and my family to kind of give us a little bit of security to feel like that we're not being monitored when we come and go, because this individual just doesn't want to go out there and move the light. That light is the only light that is positioned in a different angle than what the builder put up. All the other lights he had are, you know, but I'm just, you know, it's just,
8 foot would probably be fine if we were both on the same level, but their house sits up higher than ours.
And y'all are in the darker house?
yes, sir, we are.
I got you. Okay. Questions from the board?
You had mentioned, I think, about when you put the fence up, something about landscaping and trees. Are you putting some trees?
We already did. We would have put the trees there, but if you look at how narrow the area is from where the driveway and the property line, I'm not gonna plant a tree that's gonna encroach on somebody else's property, because we did plant emerald greens on the front, and we planted emerald greens on the back side going down the property line of the, of our
So it's
property.
like a partition, it's not like a full fence and, you know, it's a section that blocks that area and there's trees in front of it and trees behind it, because those were the spaces that we had enough room to plant emerald greens. But we couldn't do that right next to the driveway, we only had a certain amount of space.
And emerald greens typically usually get 4 to 5 feet wide, and we only have about maybe 2.5 foot wide from the property line to
Thank you.
the driveway.
Other questions from the board? Okay, if there aren't, thank y'all very much. Is anyone else here wish to address 4148 Bentley? Yes, ma'am, come forward, please.
Hi, my name is Wendy Horton. I live at 1206 Janie Sue Court, and I'm here on behalf of Bob and Amy Baird, who live at 1209 Janie Sue Court. They could not be here. Amy has stage 4 bile duct cancer and was just put on hospice last week, so they unfortunately couldn't be here, so they notified me a couple days ago and asked if I would come and be here on their behalf.
And what is their address?
They are 1209 Janie Sue. They're right next door.
Okay.
So I wanted to give you some photos. Oh, I also have a petition here that I circulated with some of the neighbors. Couldn't get to all of them because I went actually last night and retrieved signatures. I spoke with Commissioner McFarland, and he had suggested that I get some signatures from neighbors to show that we are in opposition of this particular fence that was put up. So I have that here. I also have photos of the issue at hand. Clearly he's in violation of the easement code. If he were to put the fence within the guidelines, he would have to put the fence in the middle of his driveway, basically, in order for it to be appropriate. Here is a photo of...
These are guidelines based on the homeowners association?
No. This is guidelines based on the...
I think he's saying if the
on
zoning
county.
ordinance, if he complied with the zoning ordinance, the fence would be over here.
That's for a 10-foot fence, but he can put an 8-foot fence. So in other words, he could take 2 foot off the fence and leave it as is.
And it actually may be 4 foot off the fence, just based on our site review, because it looks like it's about a 12-foot high fence.
But if he
This
had
is
an
a
8,
this is a straight on shot.
That's a straight-on shot, and as you can see, the fence is already leaning towards the Baird's property. There's another shot that I took from the Baird side of the property. Now, I know that the Bentleys have brought up that the lighting from the ring light is an issue for them. I have several photos that counter that. Here's one that's just with the regular, this is the Bentley's home, this is the Baird's home. You can see the Bentley's lighting that they have, their landscape lighting, lights up the entire side of the Baird's home. The fence that they put up does not deter that. It does not deter that at all. This is what it looks like at Christmas time. And these are the floodlights that the Bentleys have on their house. Oh, this is the inside of the Baird's master bathroom at nighttime. That was taken at 3 a.m. one morning. And then these are the floodlights coming from the Bentleys shining onto the Baird's house. So I'm also a member of our board of directors for the HOA, and we had discussed this. We felt that this is a county issue that trumps the HOA covenants. The covenants do not allow for this fence to be built where it is built, but because this is a county issue, we felt that the county should be the one who takes care of it. Yes, there's a huge dispute between these two neighbors. I have letters from the attorneys back and forth, and as the neighborhood, we want this to be done right. We know that he did not get a permit for this fence, because if he did, it wouldn't have been approved. If he had applied for it, it wouldn't have been approved. So we just hope that the right thing is done at this point.
Oh, thank you.
Thank you.
Anyone else here wish to address 4148 Bentley? If there is not, then we'll close the public comment period. And we'll turn to the board. Do we have any discussions, or do I hear a motion in regard to 4148? Let me just say that for the record, that it's nice that people get together and they have petitions and that type of thing. We can't consider in most cases petitions. This is not a popularity contest. We're not counting sides or anything like that. We're simply taking a look at the issue, the applicant, the application that is, and how it relates to the zoning ordinance. And we heard a lot of comments here this morning about the light fixtures and whatnot, and I don't think that has any bearing at all on the fence issue, which is the issue in front of the board. So, that being said, do I hear a motion in regard to 4148? Tom, I'm trying to revisit your comments, and so you would not recommend approval, is that right?
By the letter of the ordinance, I cannot, no.
You cannot,
Unless,
okay.
I was just pointing out there may be a possible hardship based on topography that you could consider.
All right, do you hear a motion?
I think I'll make the motion that we approve based on a hardship to the folks that live at that address.
I have a motion to approve the request for 4148. Do I have a second?
And that hardship would be based on the topography of the land, the landscape, the fact that one house sits quite a bit higher than the other.
If you'll go back one slide, you can kind of see at least the county's 5-foot topography. The blue line is the lot that this house is on. If you'll recall from the previous picture, roughly where the house sits in the parcel, it appears that the neighboring house may be 5 to 7 feet higher.
But this is new. That was that way. This is a new lot. I mean, a new subdivision.
That's correct.
This was that way when they bought it.
That's
Our
correct.
house was built, I'm sorry, our house, I'm sorry.
That's correct.
I mean, this is a current subdivision.
Mhm.
So how do you get a hardship out of a topography
it's a
issue that was
it's a-
there when they built the house?
It's a geographic issue they didn't cause.
But it was evident to them when they bought the house?
True.
Maybe the flood lot wasn't evident to them when they bought the house.
That's possible. That's not.
That's
no.
bringing up the flood
All right,
lot
folks.
she didn't want to bring up. but
Hold on. Public comments closed. We're gonna have to just rely on the board now, okay? Okay, so we have a motion, we have a second. Any
Who
further?
seconded?
Who seconded?
I did not second. No, I have a question for the topography.
I think did you second, Perry?
No.
No?
No second.
Okay, they don't have a second yet. Hold on, stand by. You made a motion to approve. Do I have a second? Motion fails for lack of a second. Now let's go back to some general discussion. Justin?
With the topography of the lot being like that, the fence is in such a short area, I don't think that we can consider that a hardship. If it did run the entire length of the lot and they were at a 4-foot area disadvantage on the front end versus the back, you could see a hardship. But just the section of it, the short section at 12 foot, as Mr. Tom said.
It looks like it's about 12 foot high on site to us.
It's 9 foot, 10 inches.
I'd like to make a motion to deny based on language ordinance.
Okay, have a motion to deny 4148 Bentley based on language in the ordinance or lack thereof. Do I have a second? And I'll second. Okay. So we have a motion and a second to deny 4148. Do we have any discussion? If there's no discussion, all in favor vote aye. Aye. Opposition vote no.
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 Okay, hold on. So the motion was to deny the application. All in favor, raise your right hand. Okay, all opposed, raise your right hand. Okay, so the motion fails. All right, floor is open for a motion now.
I want to make a comment.
Yes, sir.
It's, of course, we're not here to talk about floodlights and all that, but it's hard to believe that this couldn't be solved by just a few adjustments and everybody goes home happy. But
I mean, if they moved the fence 10 feet or more inboard of the property, which I think 10 feet would be in the middle of their driveway, but they could, there's nothing that precludes in the zoning ordinance them moving that fence further inboard towards their house on, maybe on the inside of the driveway.
That would be much less appealing, I would think.
That
to
would
the
be
whole
much,
neighborhood.
much less appealing, but
Much
it would be
less.
zoning compliant.
Exactly.
And that, we're not here to talk about what's much less appealing on the zoning ordinance, but
The issue to the board is very simple. Is there basis for a variance for this fence? That's it.
2 foot.
Is it 2 foot? Yeah, 2 foot.
2 foot fence. I'll make a motion that we approve this case for 2 foot height variance based on the topography of the land.
I'll second.
Have a motion and a second to approve the variance based on the topography of the land. Second by Mr. Crockett. Any discussion? If not, all in favor vote aye.
Aye.
How many, right hand, how many people vote aye? 2. Okay. All opposed vote no.
No.
3 voting no. Okay, motion fails. Okay, back to the floor being open for a motion. In regard to case 4148, I move that we do not approve the request. Do I have a second?
Second.
I have a motion and a second. Now discussion. If not, all in favor raise your right hand. Okay. All opposed raise your right hand. Motion fails. Okay. Floor is now open for a motion. Not taking action is not an option.
I'll make a motion, we approve it.
We already had that motion.
Well, we've already had what other motion is it? We've had both motions.
I got you.
I'll make a motion.
I have a motion to approve 4148. Do I have a second?
I'll second.
I have a motion to approve 4148 properly seconded. Is there any discussion? If not, if you're in favor of the motion to approve 4148, raise your right hand. 1, 2, 3. All right. Opposed? Motion to approve passes. 3 voting aye, 2 voting no. Thank y'all for coming.
So the variance for a 2-foot request is granted.
That's
Hardship
correct.
being the hardest of the land.
Thank you guys very much. We appreciate it.
All right. Our next case is case 4149, Alejandro Serrano, on behalf of Sonia Hampton, is requesting a variance of 5 feet from the rear yard setback requirement of 40 feet and a variance of 5 feet from the south side setback requirement of 15 feet. The variance will allow the proposed addition to be 35 feet from the rear property line. The existing house is 10 feet from the south side property line. The variance will allow the addition to be lined up with the existing house. The property is located at 902 Glayville Road, parcel 30, on Wilson County Tax Map 116. The property consists of .18 acres and is zoned R1 residential. Let's get staff recommendations now on 4149.
Mr. Chairman, Alejandro Serrano, on behalf of Sonia Hampton, is requesting a variance of 5 feet from the rear yard setback of 40 feet, leaving 35 feet, and a variance of 5 feet from the south side yard setback requirement of 15 feet, leaving 10 feet to the property lines. The variance will allow the proposed addition to be, again, 35 feet from the rear property line and 10 feet from the south side property line. The variance will allow the addition to be lined up with the existing house. The house was built in 1965 and constitutes a grandfathered non-conforming structure on an older lot of record. Staff sees little adverse effect in granting the variances requested and can recommend approval. In closing, the property could be cleaned up a little bit once the construction is completed. There was some question about whether or not there was a zoning compliance issue on property, but at least initially we determined there probably was not, that some of the mess may be associated with the construction on the property. There was an unserviceable vehicle, but they're allowed to have 2.
Okay, who's here to represent 4149? Serrano. Yes, sir. Name and address for the record, please.
My name is Alejandro Serrano, and my address is 902 Glayville Road. And I'm here to represent Miss Sonia Hampton. I tried to do an extension to the existing building, which it's kind of like crooked, and it's not. I got right here. I think I give them a drawing of how the house is and what I ask him for. And the side of the house, it's let me give this to you.
We got it.
Oh, you got that?
Mhm.
And the side of the house, it's an existing from the property line, and I just want to add a room in there. The property line, it's kind of like crooked, so in one side of the room I want to build is 40.6, and the other corner is only 25 feet.
Does the board have any questions for the applicant?
I do. Hi.
This is-
Questions here, we're talking about violations, and the pictures that we're looking here, you're talking about it could be cleaned up after construction?
Well, a lot of the items, they're like construction materials. And we have a car. My son is he's gone to school for mechanic, and he took apart the engine, but it's the only one that's not working. The only vehicle.
Could I see that again, Mr. Crockett?
I don't see sort of a big issue with the variance, but myself as a board member, I'd feel better. Those things were cleared up before you, and you come back to the board to ask for a variance. I don't know if we can put that into a motion, but.
To be clear, he's allowed to have the unserviceable vehicle. He can have 2.
Yes, sir.
The car there with the hood off and no front, that he's allowed to have that, is he not? That's
Is
not
that
a
a-
zoning violation.
Is that in the zoning ordinance, or is that a policy?
No, that is in the zoning ordinance.
It's not a
Okay.
zoning violation.
All right.
But there's a limit to how many of them he could have. 2.
And how long has this construction been going on?
I just started like a couple months ago.
There was a stop work posted on the property.
to get a permit,
to
right?
get a building permit.
Okay. Does the board have any other questions for the applicant? Thank you, sir. Anyone else here wish to speak to 4149 Serrano? If not, we'll close the public comment period and turning to the board for a motion.
Mr. Chairman, I will move to approve, based on staff recommendation, to do the older lot of record.
Have a motion to approve 4149 based on staff recommendations. Do I have a second?
Second.
Have a motion and a second. Discussion by the board. If there's no discussion, all in favor vote aye. Aye. Opposition vote no.
No.
Have 4 yes and 1 no, correct? All right.
Who was the no?
Motion passes.
Who's the no?
Mr. Crockett.
You voted no?
No. Correct.
And Manny, you second, right?
Yes, sir.
Okay. Thank you, sir. All right, our next case is case 4150. Kevin Wolcott is requesting a variance of 28 feet from the road frontage requirement of 50 feet. The property has 22 feet of road frontage. The variance will allow the property owners to replace the existing house built in 1918. The property became of record prior to July 10th, 1974. Property is located at 1550 Poplar Hill Road, Hobson Pike, parcel 24 on Wilson County Tax Map 90. The property consists of 175 acres and is on A1 agricultural. We get staff recommendations on 4150.
Mr. Chairman, this is Poplar Hill Road up here. Again, this is a larger acreage tract that comes down a flagpole or flag stem to the buildable portion of the tract. I believe it's 175 acres. The existing house that's on the property that I think is being replaced is, I believe, back in this vicinity. Kevin Wolcott is requesting a variance of 28 feet from the road frontage requirement of 50 feet. The property has 22 feet of road frontage in existence. The variance will allow the property owners to replace the existing house that was built in 1918. The property became of record prior to July 10th, 1974. Staff sees little adverse effect in granting this request. This is an older tract of record. While the recorded boundary survey is relatively new, being recorded in November of 23, the tract and acreage have been in place since prior to 74 when the county began enforcing zoning. Staff can recommend approval. We did get one email, or I believe Karen's office did receive one email from a lady who could not make it here due to weather, who did express concerns, not necessarily with this request specifically for this particular applicant, but was concerned, if I can paraphrase or summarize what she said, she was concerned about the variance running with the land for additional property owners down the road, or subsequent property owners down the road, and it somehow affording them the opportunity to further develop the property with additional lots and homes. All I can respond to that is that as long as they have the 22 feet of road frontage they have, it's not going to be able to be subdivided without further variance from this board, and then or obtainment of additional road frontage from another lot back to a public road. So I don't think that the concern that I summarized is a valid one.
Okay. Who's here to represent 4150 Wolcott?
I'm Myra Walcott. My current address is 224 Callis Road in Lebanon. And we purchased this property at the end of the year in hopes to be able to build our forever home. And we have a current 5 acres with a farm and 4 kiddos, so we hope to move there and continue to grow our current farm.
Okay. Board have any questions for the applicant?
And there was or is an
There still
existing
is.
home?
Yes, sir.
that
There's
you're
still an
gonna-
existing home and an old barn as well.
And you realize this is for one house. You can replace one house.
Yes, sir.
Okay. All right. Board have any questions for the applicant? If not, does anyone else here wish to address 4150 Wolcott? If not, thank you. We'll close the public hearing on 4150 and turn to the board for a motion.
I'll make a motion to approve.
Have
based
a
on
motion to
staff
approve
recommendations.
4150 based on staff recommendations.
Second.
Have a motion and a second. Discussion by the board. With no discussion, all in favor of the motion as stated, vote aye. Aye. Any opposition, vote no. The ayes have it. Thank you. Okay, our next case is 4151. Anthony Johnson is requesting an additional 8 feet variance from the west side yard setback requirement of 20 feet. The variance will allow the proposed addition to be 7 feet from the west side property line. The board approved a variance of 5 feet allowance to the house to be 15 feet from the west side property line, and a variance of 20 feet from the rear on September the 21st, 2007. Property is located at 710 Pebble Point, Lot 6. Pebble Point Estates is Group B, Parcel 2, on Wilson County Tax Map 24H. The property consists of approximately .38 acres and is zoned A1 agricultural. With staff recommendations now on 4151.
Mr. Chairman, Anthony Johnson is requesting an additional 8-foot variance from the west side yard requirement of 20 feet. The variance will allow the proposed addition to be 7 feet from the west side yard property line. The board approved a variance of 5 feet, allowing the house to be 15 feet from the west side yard property line, and a variance of 20 feet on the rear of the property on September 21st of 2007. The lot also received a 25-foot lot width variance in December of 2017. This is an older substandard and non-conforming lot of record in terms of overall size. It is in a subdivision that was recorded in 1962, well before zoning was being enforced in Wilson County. Staff sees little adverse effect in granting this request and can recommend approval.
Okay, who's here to represent 4151 Johnson? Yes, sir. Name and address, please.
Anthony Johnson, 710 Pebble Point Road, Lebanon, Tennessee.
Okay, and what would you like to tell the board, sir?
This neighborhood's a mess. I think y'all are aware of that, as far as the lot lines and things of that nature. I'm just looking to put a carport on there to protect some of my assets, like a boat and a truck, so.
Okay.
Improve the value of my home, improve my neighbors' values of their homes.
Any questions from the board for the applicant?
Is the 708, is it still have the porch that is beside you to the left if you're looking at the house?
708. On the west side of the residence?
Yes, sir.
There is a porch there. I think they're getting ready to redo it.
I think that serves as their front door for that house, the way it was angled. It doesn't have a front entrance to that house.
The McKinneys rarely use that door for my just.
Are you talking
I've lived
about here,
5.5
Mr. Mayor?
years. Yes, sir.
Yeah.
But they typically enter on that side entrance on the west side of their home. I've spoken with them. They've
And the carport.
Yes.
I'm having trouble remembering from our side view. Is it going right here?
Yes.
Okay. Any other questions from the board? If not, does anyone else here wish to address 4151 Johnson? If not, then we'll close the public comment period and turn the board to the board for a motion. Do I hear a motion in regard to 4151 Johnson?
Move to approve based on the staff recommendations.
Have a motion to approve based on staff recommendations. Do I have a second? I'll second. Any discussion by the board? If there's no discussion, all in favor of the motion as stated, vote aye. Aye. Opposition, vote no.
No.
Have one voting no. So we have 4 in favor, 1 opposed. Motion passes. Thank you, sir. All right, that concludes our regular slate of cases. Mr. Bashir, do you have anything else for us?
No, sir, it's rather cool in here. A little airish.
Appreciate everyone coming, and we are adjourned.